All law students know there can be no contract without consideration. Thus, in Lawrence v. Ingham County Pre-Natal Clinic, a patient who received free medical services had to come up with a different argument for why she had a contract. Ethel Lawrence went to the Ingham County Clinic for prenatal care during her pregnancy. Slightly after her due date, Lawrence went into labor. The fetus was in distress and suffering prenatal asphyxia. The doctors performed an emergency C-section. The infant, Jessica, was born with permanent brain damage. Lawrence theorized that fetal distress could have been averted had the clinic applied standard procedures for postmature fetuses. Lawrence sued the clinic. After the clinic was granted summary judgment on her negligence claims, she amended her complaint to include 2 counts of breach of contract, arguing that a mutual exchange of promises created an implied contract between her and the clinic. Lawrence alleged that the clinic had promised to provide medical services within the existing standard of care. In return, she'd promised not to have an abortion and to follow clinic directions during pregnancy. Lawrence argued that by doing what she wasn't obligated to do and refraining from doing what she was legally entitled to do, she furnished valuable consideration in exchange for the clinic's promise. The trial court held that Lawrence failed to state a claim for breach of contract and granted summary judgment to the clinic. Lawrence appealed to the Michigan Court of Appeals.